On this episode of Law Weekly, Lagos State takes its plea and sentence bargain sensitization to the custodial centers. The Attorney General and Commissioner for Justice leads top officials of his ministry and other key stakeholders to the Kirikiri Maximum Custodial Center. Also showing on the program, the International Federation of Women Lawyers, FIDA Nigeria Lagos branch, holds its annual Law Week with a focus on the African child's right to life and a stable home, towards eliminating social conflict in Nigeria. Plus our recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shuyeli. On Thursday, the 17th of June, the Lagos State Attorney General, the Solicitor General of the state, and other key stakeholders in the administration of justice were at the Kirikiri Custodial Center to educate inmates about plea and sentence bargain. These became necessary to decongest the growing number of awaiting trial inmates in the custodial center. The Controller of Corrections Lagos State Command, Adewale Adebisi, puts the figure of awaiting trial inmates in Lagos at over 6,000.
In Lagos State today now, we have a total of 8,000 inmates, out of which we have 6,800 as awaiting trial persons. You will agree with me that the larger percentage of the inmates that we have at custodial centers are people awaiting trials. And there are some of them that have stayed in the custodial centers for long. We have people who have been standing trial for the past 10 years, cases of 11 or 12 years. A lot of measures have been applied in the time past to make sure that this population is reduced. But we have not been able to achieve the maximum results expected. And the judiciary, let me say the criminal justice system as a whole, all stakeholders have been putting their best to make sure that this menace is reduced.
The Solicitor General and Permanent Secretary, Lagos State Ministry of Justice, Ms. Titilayo Shitabe, explains to the inmates what plea bargain and sentence is about and how it works.
Plea bargain essentially is a tool for the congestion of prisons. It's a diversionary tool. It takes us away from the long-drawn trials that people go through in court. So it helps to decongest the correctional centers, and it also helps to decongest the dockets of the judges. Now, we have a general belief, or there's a myth, that plea and sentence bargain is meant for the rich and the well-connected in our society. Well, we are here today to demystify that belief. We have made the process of plea and sentence bargain in Lagos State Ministry of Justice a very simple, straightforward process, and that is deliberate. It's meant to be very simple, straightforward, and transparent, so that it can be accessible to anybody, whether you are literate or illiterate, whether you are represented or unrepresented by counsel.
The Attorney General of Lagos says that this is one of the many programs of the state government working in partnership with key stakeholders and the inmates who are often referred to as students within the correctional center.
The Lagos State government has designed many programs to decongest the custodial centers. Plea bargain is one of those programs. And as you have heard, plea bargain is nothing more than you sit down with the prosecution, which is Lagos State Ministry of Justice, either through your lawyer or directly, and you agree with them to plead guilty either to the charges you are facing or to what we call a lesser charge. If you agree, a plea bargain agreement will be drawn up. You will sign, your lawyer will sign, the Ministry of Justice will sign, and then we will take it before the court. And I tell you that today we have our judges who are waiting to join us online. They're going to sit in their courtroom, but they're going to sit what we call virtually. So we will see them via the internet, and any agreement, plea bargain agreement that we have reached today they will make it the judgment of the court. So this exercise is not to force you to plead guilty when you have not committed an offense. Please know that. Note that. We have not come here to say plead guilty when you are not guilty. But if you know that you have committed an offense, the society, the Lagos State government, the judiciary, they want to give you another chance. And that chance is through pleading guilty to a lesser offense. So that in no time, you will be released from here, you will be rehabilitated, and go on to live a useful and meaningful life to the society.
Key stakeholders from the NBA branches in the state, the Legal Aid Council, the International Federation of Women Lawyers, the African Women Lawyers Association, the Office of the Public Defender, and other non-governmental organizations with their lawyers are here to offer free legal and social services to their awaiting trial inmates. After this information, the Director of Public Prosecution takes charge, and some of the inmates begin to take advantage of the plea bargain. Soon, the first plea bargain agreement is struck.
So we have a plea bargain agreement with Okwayemi, and he has agreed to plead guilty to a lesser charge.
At the end of the day, 27 inmates comprising 16 males and 11 females, represented by different lawyers, benefited from the plea bargain session, which was upheld by 3 judges of the Lagos High Court who participated virtually from their courtrooms. The AG explains the plea bargain is a useful tool, especially when parties have grown weary of prosecution, and this lethargy is one of the reasons for coming to the prisons.
Since we've started, we've done about 530 or so, thereabouts, close to it. Today we're doing 27. I know 530 doesn't look like a very large number from 2017. But there's been a lethargy amongst legal practitioners. There's been lethargy amongst inmates themselves. It's a continuous exercise. We're taking it to all the correctional facilities in Lagos State. So you have Ikoyi, you have Kirikiri, and you have Badagry. So we're going around. The DPP's team, the plea bargain committee will go around. So the reason for this exercise is to kind of come directly to the affected inmates, so we bypass every other thing and we bring the plea bargain offer right to their doorsteps. Through the use of technology and the cooperation of the Lagos State Judiciary and of course the cooperation of the Nigerian Correctional Services, we've been able to attack a plague and a blight in the awaiting trial numbers which affects all of us.
The benefits of plea bargain includes the fact that it saves the time spent on lengthy trials. It also saves money and cuts the cost of prosecuting and defending a criminal trial, as well as promoting the principle of restorative justice. More reactions trail the continued chisa ban by the federal government as lawyers file suits in court insisting it's a violation of human rights.
Let me state clearly that the president has erred the law by placing a ban on Twitter. You see, the use of Twitter by Nigerians is guaranteed under Section 39 of the Constitution as part of their freedom of expression. It is guaranteed under Article 9 of the African Charter of Human and People's Rights. It is guaranteed under Article 19 of the Universal Declaration of Human Rights 1948. Particularly that article says that they can express themselves through any medium and regardless of the frontiers. So where the president has derived that power to curtail freedom of expression from, I don't know. Now, that particular act has also had terrible implications for freedom of the press, for freedom of religion, for right to earn a living. Freedom of the press, because all Nigerian press houses have Twitter handles with which they propagate freedom of the press. Freedom of the press because many Nigerians do some form of journalism on Twitter now, and they disseminate information. Now, freedom of religion. They were joining issue with Pastor Iwo Adeboye, Pastor and Pastor Kumuyi, because they insisted that they would continue to use their Twitter handle to propagate their religious belief. Now, the attempt to stop them or the threat to prosecute them is an affront on their freedom of religion. We are no longer in England of 1670 when William Penn was prosecuted under the Conventicle Act for exercising his right to religion. We are no longer in that age. We are not in a police state, and every person who has been given the mandate to exercise power must exercise it in accordance with the law. Now, they have this right, and the law guarantees the right. Now, beyond that, now have about commercial freedom of expression. When you go to Twitter, many Nigerians do all sorts of things there. They do buying and selling there. They do advertisement there. They do marketing there. Some do several commercial activities there. And you now want to stop them. It then means that you are denying them their right to earn a living. So we will not take that and will not accept that. And I also wonder how the Attorney General came about the idea that he wants to begin to prosecute people for continuing to use Twitter. Has the pronouncement of the president become law that is now a basis to prosecute people? It has the Attorney General, the Lenin Attorney General, forgotten that Section 36 sub 8 and Section 36 sub 12 of the 1999 Constitution of Nigeria, as amended, has confined prosecutorial power to only things that constitute an offense as at the time they were done, and only offenses that were defined and written. Has it forgotten? So the learned AG should sit up, and I appreciate the fact that he was appointed by the law, he was appointed through the instrumentality of the law, and he must conform to law when exercising his powers.
The whole Constitution has given us rights. The federal government cannot by any means or by any guise take away this right. This right has been provided for in Section 37 and Section 39 of the Constitution. Particularly if you look at Section 37, this right, the right to telephonic and telephone conversation and thereabouts, is holistic. There is no proviso to that section, that's Section 37. No exception, no clause. That section is holistic. That section is standing on its own. There is no A, there is no B. Section 37 is Section 37. So the federal government cannot come through the back door and take the right that has been given to Nigerians by Section 37 and Section 39 of the Constitution. Perhaps they may want to hide under Section 49 and Section 45 of the Constitution and under the Cyber Act Provision Act 2015 to find justification or to find reason for this illegal suspension placed on Twitter. But there is no justification. No matter how you try to look at it, no matter how you try to analyze it, no matter how you try to justify it, there is no justification. You cannot take through the back door what the Constitution has given to us through the front door. Are you getting it? Now the issue is this. When similar thing happened in US, did Trump ban or suspend Twitter? He didn't do it. That is because over there there's freedom of expression. Their constitution provides so. And over there, they respect this constitutional provision. There's respect for rule of law. There's respect for constitution. Over there, power belongs to the people and not to the government. But in Nigeria, reverse is opposite the case. In Nigeria, our rulers, permit me to use that word, they don't respect constitution. Every day we see constitutional violation in this country.
Welcome back. The International Federation of Women Lawyers Nigeria Lagos branch has held its Law Week. The Law Week had the theme African Child's Right to Life and a Stable Home towards eliminating social conflicts in Nigeria. We have some of the highlights from the Law Week up next.
The Day of the African Child is celebrated on June the 16th every year and has been so celebrated since 1991 when it was first initiated by the Organization of African Unity, OAU. Amongst other things, the day raises awareness of the continued need to improve the quality of education and the quality of life of the African child. And it's for this discussion that FIDA Lagos has gathered all these people together, in person and virtually, to talk with a view to drawing a roadmap for the well-being, especially of the Nigerian child, some of whom are also present here.
Our theme for this year, which coincides with the UN African Child's Day, it says, African child's right to life and a stable home towards eliminating social conflicts in Nigeria. That is the theme. It is at the core of what we stand for. Protecting the rights of women and children, offering legal services to the indigent in the society. We actually do this every Thursday. We have a program, the legal clinic, that takes place every Thursday. And we talk to people, we settle cases, and they're all on pro bono matters, cases. Uplifting the widows, empowering the widows to learn skills for a better future. That is our mission. That is our goal.
The current challenges affecting the quality of lives of children is very worrisome. These include insecurity, conflict situations, vicious cycle of poverty, lack of education, lack of access to good health care, infringement of legal rights, sexual abuse, child labor, drug abuse, access to social creation, child trafficking, among others. We must continue to advocate on this and more.
This is a country where we still have children of school age hawking goods on the street. On most streets of the cities of Nigeria, we still find children of school age. We still have children herders running after cattle in 2021. So the objectives of FIDA, quite noble. You still have a lot of work to do.
In her contribution, a lawmaker from the Lagos State House of Assembly talked about the effort made so far to pass some legislations to protect the vulnerable in the society.
At the Lagos State House of Assembly, I was able to scale through my third reading on the establishment of the Lagos State Domestic and Gender-Based Violence Agency. So, and then also the establishment of the Sex Offenders Register.
The Deputy Vice Chancellor of the University of Lagos, Professor Ayo Asenua, who was the keynote speaker, dwelt on the provisions of the Child Rights Act and the Child Rights Law and how to maximize its provisions.
You cannot talk of the right of the African child to life and a stable home without talking about what is life. If your health, your chances of survival, even at birth, is low because of so many things, access to healthcare services, nutrition, etc., and all of those things. The housing condition is one major factor that's been implicated in high child mortality rates because many people, especially around Lagos, live in grossly inadequate housing that exposes the children to health risks. So we have a serious problem.
Thank you.
After her presentation, other panelists took on issues touching on ending child marriages, the impact of the Child Rights Law, and keeping the children safe in a season of insecurity, amongst other issues.
And just before we go, a look at some of the trending legal news.
We begin with the report that the Lagos State High Court, sitting in Ikeja, has sentenced a former managing director of the defunct bank PHB, Francis Atuche, to a 6-year jail term for the offense of stealing the sum of 25.7 billion naira belonging to the bank. The court also sentenced him to another 6-year jail term for the offense of conspiring with others to steal the sum. The sentences are to run consecutively, and the lead prosecutor for the Economic and Financial Crimes Commission in this case, Senior Advocate of Nigeria Kemi Pinheiro, says that this means Atuche will spend a total of 12 years in jail. Pinheiro, a private senior legal practitioner, prosecuted the case on behalf of the anti-graft agency after having obtained the fiat of the Attorney General of the Federation. Judgment in the matter lasted about 12 hours, during which presiding judge, Justice Latifat Okunu, first convicted Atuche alongside a former chief financial officer of the bank, Ugo Anyanwu. Anyanwu was jailed for 4 years each on both offences, with a sentence to run consecutively, amounting to a jail term of 8 years. Both men are to serve their jail terms at the Kirikiri Maximum Correctional Facility in Lagos. The court convicted the duo on the 21 of the 27-count amended charge of conspiracy to commit felony and stealing brought against them by the EFCC. Justice Okunu held that the EFCC successfully proved its case against the convicts beyond reasonable doubt. She freed Atuche's wife, Elizabeth, on the grounds that the EFCC failed to link her to the crime. Still in Lagos, a federal high court sitting in Ikoyi has acquitted and discharged the senator representing Delta North Senatorial District Peter Mwoboshi on allegations of laundering 322 million naira. Justice Chukwujeku Aneke held that the Economic and Financial Crimes Commission (EFCC) failed to prove the elements of the offences against the lawmaker. The judge also declared Mwoboshi's two firms, Golden Touch Construction Project Limited and Suremain Electrical Limited. Justice Aneke held, among other things, that the EFCC's case collapsed because bank officials were not called to testify and prove the money laundering charge. Mwoboshi, a People's Democratic Party chieftain representing Delta North in the Senate, was arraigned alongside his companies in 2018 before Justice Mohammed Idris, who was later elevated to the Court of Appeal. This necessitated a rearrangement before Justice Aneke in October 2018, who has now freed the defendants. In Abuja, a federal high court has rejected an application by the EFCC to amend its charge in the trial of a former group managing director of the Nigerian National Petroleum Corporation, Mr. Andrew Yakubu. In the ruling, presiding judge Justice Ahmed Mohammed held that allowing the EFCC to amend the charge was tantamount to disobeying the subsisting order made by the Court of Appeal in its judgment on April 24, 2020. The appellate court had ordered Mr. Yakubu to enter defense in relation to counts 3 and 4 of the 6 counts originally contained in the charge on which he was arraigned. The EFCC arraigned Mr. Yakubu on March 16, 2017 on a 6-count charge relating to money laundering offences. He was, among others, accused of failing to make full disclosure of assets, receiving cash without going through a financial institution, which borders on money laundering and intends to avoid a lawful transaction under law, transported at various times to Kaduna in the aggregate sum of $9.8 million and £74,000. The prosecution closed its case on October 17, 2018, after calling 7 witnesses. When Justice Mohammed ended the ruling, the defense indicated its intention to proceed without its case, but the court elected to adjourn till June 30 following a plea by the prosecution for an adjournment. In Ondo State, the Federal Court of Appeal sitting in Akure, the state capital, has dismissed the suit filed by Eitayo Jegede against Rotimi Akeredolu, challenging the eligibility of the latter to contest for the 2020 governorship election. Jegede, who contested under the platform of the PDP, had approached the Court of Appeal on the ground that Akeredolu, the APC candidate, was not properly nominated by his party to contest the election. According to Jegede, the current governor of Yobe State, Mai Malabuni, who presided over the nomination of Akeredolu as the APC candidate, was also not constitutionally qualified to do so, and he argued that this invalidates the process. The presiding justice in the Court of Appeal, Justice Teresa Oji Abadwa, who delivered judgment via a virtual platform, ruled that the appeal filed by Jegede lacked merit and he dismissed it. The other judges on the panel agreed with the presiding judge that the case lacked merit. Hopes of freedom for popular Yoruba actor James Olanrewaju, also known as Baba Ijesha, was dashed by a chief magistrate court sitting in the Yaba area of Lagos. Magistrate Peter Nwaka refused to vary his bail condition on charges of rape, sexual assault and abuse of a minor. The magistrate sent him back to the custody of the police pending his arraignment by the Lagos State Director of Public Prosecution (DPP). Baba Ijesha was brought to the court by the police around noon alongside other crime suspects and arraigned on a 5-count charge. He pleaded not guilty when the counts were read to him. The police prosecutor in the matter has however told the magistrate that proceedings concerning Baba Ijesha will now be handled by the DPP following an information filed before the High Court. The magistrate has also ordered that the defendant must be accorded full medical attention by the authorities pending his arraignment at the High Court.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shayeli. Thank you for watching and see you next week.